Because I have some people on from Lancaster on the phone.
Hello, Lancaster.
Can you hear me, Lancaster?
Yeah.
Okay, if there's any. Yeah, sure. Tell me when you're ready. If you guys ask any questions, I'm going to ask them at the end, and then I'll repeat them so everyone can hear it on the phone. Did everyone get a handout?
Yeah.
There's some attachments to the handout, and I'm going to be referring to the form numbers that are on the bottom of the pages throughout the course of the presentation. There's really only one or two things you'll need to look at, but just to hang on for future reference. That's really the purpose of it. Are you both ready? Lancaster?
Yeah.
That's one of you. Just one more second. Are you there? Okay, I'm going to start. My name is Paul Metzger. I'm going to be talking to you about the Child Abuse Central Index. And like I said before, I'll take questions at the end. I'm hoping to accomplish four things today. I want to give you a general overview of the index, what it is, and how it potentially could affect all of your clients. I'm going to explain to you how your clients can figure out if they're on the index and how you could assist them in doing so. If they are on the index, I'm going to explain how you can preserve their appellate rights so they can try to get off of the index. And most importantly, at the end, I'm going to talk about the jurisdictional hearing in children's court and what not to do, or at least if you have to do it so you can give your clients informed consent for potential impact of how they proceed in the jurisdictional proceeding, how it could and probably will impact their right to grievance hearing. So the Child Abuse Index was established in 1965, and it basically is a database that's maintained by the state's Department of Justice. If you're an adult, when you're placed on the index, you're on it for the rest of your life, unless, of course, you have a grievance hearing and you get off of it. If you're a minor, you're placed on it for 10 years from the time you're placed on it. The index primarily serves two purposes. The first purpose really doesn't impact us, but I'll explain what it is. It's a tool for state and local law enforcement agencies and child welfare agencies across the state to compare notes about suspected child abuse, sex abuse, and exchange information about victims. Basically, they'll contact, if they find out someone's on the index, they'll contact the listing agency, ask for police reports, social study reports, and just share information back and forth. The second purpose of the index, which really impacts everyone here, is for background checks. There's two types of background checks that they use the index for. One is for placement assessment, and that includes assessing all adults and all minors that are residing in potential non-relative placements, all adults and minors who reside in relative placements, and it's also part of the home study process for any adoptive placement. So they'll do a CACI check on every single person that lives in that home. The second less known use for the CACI index is employment background investigations. This, unfortunately affects lots of our clients. If you're applying to be a police officer, any sort of job where you need a license, an LMFT, an MFT, etc., they're going to do a background check and determine if you're on the index. If you're in the military, it'll preclude you from becoming an MP. Teachers get checked, foster parents get checked, daycare facilities get checked. Every employee, from the person who's the janitor to the people that are actually giving therapy and taking care of the kids. So if anyone is on the index and they're employed already, they're going to get fired because otherwise the agency will lose their license through DSS. And obviously, if their name comes up in the background check, they're not going to get hired. So it has a pretty far-reaching impact, especially if they're an adult, for the rest of their life. So even though we're not, we might be done with their case in children's court in 6 months or 12 months or 18 months, this follows them for the rest of their careers. In 2008, unfortunately, the Department of Justice expanded the access to the database to other states besides California. So everything I just said now applies for former California residents that move anywhere in the United States. If they're on their job application, they list their last job or their last known address, their last residence rather, as a California residence. Then those agencies, the law enforcement agencies, the licensing agencies, the employers are all going to check with the California index, and they're going to share that information. So in a nutshell, that's what the index is, and that's what the purpose is. As far as the types of abuse that are reported to the index, it's very similar to the 300 code section. So sex abuse, exploitation, physical abuse, severe neglect, emotional abuse, and will or failure to protect. So I said the last part intentionally last because there's failure to protect or unable to protect is a very common code section that we have to deal with in children's court. And the difference is with the penal code sections, it has to be a willful failure to protect. So it's not unable to protect, it's knowing about the potential abuse and still not doing anything about it. I'm going to talk about the penal code sections I'm referring to in more detail at the end of the presentation. But for everyone's reference, I did attach the penal code sections for your reference are 111.64 through 111.65.6. I've attached the full text of all the statutes to your packets. So let me tell you a little bit about the listing process, who can put people on CACI, how it's submitted, etc. So in general, police departments, sheriff's departments, county probation departments, and child service agencies are the agencies that submit the paperwork to place your clients on CACI. I've attached the form that they use to put someone on CACI. It's the BCIA 8583 form, and if you take a look at it at your convenience, it's pretty self-explanatory. Basically, they include the names of the suspect, the suspected abuser. They include the names of the victim, the reporting agency who actually reported them to the index, and the type of abuse that they found actually has occurred. So that's also important. I'll say that now. So if you're on the index, that means that the investigation has been completed by whatever agency conducted the investigation and substantiated whatever the abuse allegations are. So you've already been found to have committed the particular abuse, and you're on it for life unless you actually have a grievance hearing and try to get off of it. That's also the same information that all these agencies will share with each other. So, for example, if LAPD investigated for someone for child abuse, put them on the index, and then the person moves to Colorado, then they'll contact LAPD, they'll get a copy of the push report from LAPD, the name of the victim, and then obviously the name of the suspect. So let me talk a little about the rights of the people that are listed on the index. Before 2008, if you were listed on the index, you had no rights whatsoever. You weren't given notice that you were on the index. You weren't told why you were placed on the index if you found out you actually were on the index because, say, for example, you applied for a job and they told you they weren't going to hire you. And there was no, most importantly, there was no procedure to have your name removed from the index. And then that prompted a lawsuit against the Department of Social Services by an individual named Mr. Gomez. And that case name is Gomez versus Saines. And the case eventually settled, and there was a judicial-approved settlement which gave people that were on CACI listees a number of rights, which we're going to talk about today. The first right that case gave CACI listings was you have you have to be given notice that you're placed on CACI within 5 days of the submission of the 8583 form. That's a little tricky. They're supposed to give you notice that I attached the notice form, which probably you should look at now. It's form number 832, SOC 832. So pursuant to the terms of the settlement, everyone within 5 days of being placed on the index is supposed to receive the 832 form. And this form will say the victim's name, it's not redacted. It'll say the dates of the alleged abuse that were substantiated. And then most importantly, it'll actually state the penal code that you're being placed on the index for. This is the document that you want to try to get from your clients first, because you'll be able to find out the specific penal code that they were found to have committed, which we'll talk about in more detail in a few minutes. Besides notice, the Gomez versus Science case gave CACI listees the important right to have an appeal to try to get off of the index. That appeal process is really a quasi-administrative hearing, and it's called a grievance hearing. Just in a nutshell, the grievance hearings are usually take place at the DI workers, the office that they're working out of in a conference room. There's going to be the DI or the ER worker, sometimes both, a county counsel, usually the outstation county counsel from that office. There's going to be a grievance hearing review officer who's not a judge. They're usually not even lawyers. LA County has 3 full-time grievance hearing review officers, and they're basically marriage and family therapists. Some of them worked as social workers in the past. And they're not really familiar with the law, although they do know about particular penal codes that we're referencing today. I've actually found the hearing officers to be extremely fair. I think they're neutral, even though their office is located, in DCFS's suites. But they tend to be fair, and I've had a lot of success. They hear evidence. They issue written decisions. They're supposed to do it within 30 days. Usually takes 3 or 4 months. But I found that they weigh the evidence of both sides, and they try to do their best job to render a fair decision. So that's the background on the index. So let's get to the nuts and bolts of this talk. So I think everyone in this room should probably add a couple of questions to their initial client interview after today to determine if their client is on the index. So the first question I would ask is if they received an 832 notice that they're on the index, and if they did, I would ask them for a copy of that index so you can make note of the penal code that I keep talking about. The problem is that the notice requirements under the Gomez case are significantly less restrictive or comprehensive than judicial notice. So they're only required to give notice to the last known address of the suspect, and they really make no effort to find the current address. They often use the wrong address. So I say at least 50% of the cases I've had that the person on the index never received the 832 notice at all. And they're supposed to make an effort to verify that the last known address is their current address, but they never do. So at the intake interview, one of the questions I would ask them, besides if they're on the index, is if they've moved in the last couple of years. And if they've moved in the last couple of years, I would obviously ask them if they have their mail forwarded. If they don't know if they're on the index, which is probably the likely scenario, they could do a self-inquiry. There's 2 ways to do a self-inquiry. That's basically the client, not you, the client reaching out to the Department of Justice and asking them if they're on the index. It's not a very simple process because they have to have the request notarized. So my experience is it's hard to get your clients to do it. But there's 2 ways to do the self-inquiry. The first way is via the form, the 4506 form that I've attached to your packet. It's pretty self-explanatory. They fill it out. They have it signed by a notary and just mail it in. And then the second way is just for them to send a letter, basically requesting the same information. So that's how you find out if your client is on the index. So let's assume that your client is on the index. Let me tell you what you immediately need to tell them to do. So I've also attached a form called an 834 form, and that's the form they need to fill out to request a grievance hearing. If they received an 832 notice, so that's a notice from the Department of Justice basically saying they're on the index, they have 30 days to submit this form. I'll talk about the 30-day time period in a second because it gets tricky. If they did a self-inquiry, they have 120 days from receipt of the notice that they're listed on CACI to make a request for a grievance hearing. The problem is that the 30 days runs from the date of the notice. And since the county always uses county mail, I've never seen a notice that wasn't sitting in the outgoing bin for over a week, sometimes 2 weeks. So even though they're supposed to have 30 days, in general, they really only have 7 to 15 days to actually make a request for a grievance hearing. And like every other thing we deal with, if there's a way to deny the person a grievance hearing without a hearing, they're going to do it. So it's important to make sure that they timely make a request for the grievance hearing using the 834 form. I have a couple tips that I found useful when my client misses the 30-day deadline, which happens more than I would like. I always tell my clients to keep the letter that the notice came in, because the postmark is going to reflect the actual date that the notice was mailed. I found that the chief grievance review officer will take that into consideration. So if they missed the deadline by 7 days or 10 days, and then the grievance review officer could be shown that the mail wasn't received, they didn't have the notice for the full 30 days, they usually give your client a couple extra weeks and grant the request for a grievance hearing. Another tip is if your client missed a 30-day notice period, that according to the manual, they're supposed to, the noticing agency, which is in this case it's going to be DCFS, is supposed to keep a log of the date they actually mailed the 832 notice. So I would request a copy of the page of that log so that we could prove the date they actually mailed out the notice. And just as a general tip, the notice is sent out via first-class mail. There's never a proof of service. I don't think the grievance review officer even knows what a proof of service is, to be honest. So you could always claim that your client never received the notice, assuming they didn't. So what I do in general, if my client is on the index, didn't request a grievance hearing in a timely manner, I'll go ahead and I'll write a letter explaining the situation and ask for an extension and a request to file the 834 form late. And more often than not, they'll grant it if your request is reasonable. Okay, so let's assume that your client is on the index, in a timely manner requested a grievance hearing. Let's talk about the important part of this presentation, which is how to handle a 300 petition. Because the 300 petition is going to have a direct impact on their grievance hearing rights. So just to take a step back, the grievance hearings are operated by the Office of Appeals Management for the county. So they're the employees that are going to be managing this whole process. According to the Gomez element I referred to earlier, they're not required to give your client a grievance hearing if this is true. I'm just going to read the actual language from the Gomez element. If a court of competent jurisdiction makes a finding that the reported abuse or neglect occurred, they're not required to give a grievance hearing. So basically that means that if you resolve a 300 petition and your resolution of that petition is similar to the language that placed them on the index, that's a court of competent jurisdiction, whether it was a waiver or a finding after a hearing, and your client's going to be denied the grievance hearing. So let me back up a little bit and explain the specific process, the order of the process. So when your client requests a grievance hearing via the 834 form, a couple of things happen. The first thing that's going to happen is the Office of Appeals Management is going to send a letter to your client denying the grievance hearing on its face. If there's a pending case in children's court or criminal court or civil court even, they're going to send you a letter basically saying we received your 834 request. However, because there's a court competent jurisdiction that has not made a determination whether the allegations are true, your grievance hearing is denied. Sounds a little harsh, but what it really means is your grievance hearing is on hold. So you preserve the right for grievance hearing, and they're just going to wait till whatever court case is ongoing to be resolved before they either permanently deny your client the right to a grievance hearing, or in the alternative, grant your client the right to a grievance hearing. So in practical terms, how it works is the second they get a day or two after they get the 834 request for a grievance hearing, they'll contact the DI that's on the case. They actually placed your client on the index. They'll notify the DI that there's been a request for a grievance hearing, and then they'll ask the DI for regular updates on the progress of the dependency court case. The DI will be working, unfortunately, in close connection with the county counsel assigned to your courtroom. I've actually had situations where I couldn't prove it, but it felt like that I had a deal with county counsel. They got off the phone with the DI. The DI realized that this would preserve the right to a grievance hearing, and then the deal fell apart. So you're not going to be able to fool the Office of Appeals Management. They're going to get the exact amended language or sustained language, and then go from there. So to give you a couple examples, I'll start off with the positive one. If you go ahead and do a 300 hearing, and your client is entirely dismissed from the petition, they're off khaki. You don't have to do anything else. So you preserve the right to a grievance hearing, and then one is not even necessary because the allegations have been found not true by a competent jurisdiction, competent court. Let me give you another scenario. So the court sustains the petition as is. You do trial, the court just sustains the petition. That language is there's going to be confirmation between the DI and the Office of Appeals Management, and then they're going to send you a letter saying it's our understanding that the court sustained the language, the grievance hearing is off. The third option is the most complicated one. So, and the one that will make your job a little more difficult. That's trying to work out language that satisfies your courtroom and all the lawyers involved in the case and the court, and it's substantially different enough from the language of the penal code where you actually preserve your right to have the grievance hearing after the jurisdiction hearing is over. I'll give you a hypothetical. I'll do it now. So let me give you an example of that. So you say you have a client who has an emotionally disturbed child. The child is taken to a psychologist, taken to a psychiatrist, is on medication, and even after all the parents' efforts, the boy or girl still tries to commit suicide. So the parents, they file a 300C petition against the parent, accusing them of unable to protect their child or meet their child's special needs. They place them on the index under 11165.2, which is neglect, and you figure out, well, what am I going to do? So clearly the parent hasn't been able to meet their child's needs. They've done everything they can. The court's going to sustain that language. But at the same time, if I agree to that language, my client is never going to be able to get off the index. So there's not a simple solution, but that's when the penal code sections come in, where you actually have to take the penal code language, lay it right next to your 300 petition, and try to figure out a way to creatively reach some language that's going to satisfy the children's court and not violate the penal code. So, for example, if someone's placed on the index under that penal code section 11165.2, there has to be a finding that there were omissions done by the parent that a reasonable parent would have done. So in that circumstance, I would still work out language for 300C in children's court saying the parent was unable to meet the child's special needs, but I would add additional language, even though the parent did the following things, including but not limited to X, Y, and Z, the parent was still not able to meet the child's needs. I think we would have a reasonable argument that that language, even though sustainable under 300C, doesn't meet the requirements, or the elements rather, of the Penal Code section 11165.2. So it's going to make your job a lot harder, because you not only have to try to look at language that's going to satisfy this court, but you're going to have to make sure you try to work on language that satisfies, that doesn't meet all the elements of the Penal Code section. Let me give you a less obvious example. I'll try to do it off the top of my head. So I have a case now where I represent the mother, and she was married to a gentleman, and so he's the stepfather. She's not the biological father of the child. It's a decount against the stepfather, and it's a failure to protect against the mother. I think the mother doesn't have a lot of options, and the stepfather doesn't have standing to contest the allegations because he's the stepfather, not the biological father. So my focus in this case is explain to the mother that she has two options. Let me actually back up. I guess this is not hypothetical. This is a real example. My client is a government contractor. She does IT for government agencies. So her name is regularly checked through the index to make sure she doesn't have anything that would disqualify her from the government contracts. Her husband is also a partner in the company. So I have to advise my client that she has two options. She could either contest the underlying allegation, the failure to protect, which is also a J count, and through that contest try to disprove the sex abuse allegations that are being made against a stepfather. Or I could tell her, and then she probably won't get, she loses, which she probably will, she probably won't get her daughter back. Or I could tell her that even if she does do the waiver, her husband, by the way, her husband is on the index, she's not. So then I have to give her, so she can make a knowing waiver that if she does take this deal, her husband's he's gonna lose his right to a grievance hearing, and then their business is gonna lose all of their contracts unless they separate the whole business interests. So it's a knowing. So maybe I can't help her, but I can help her make an informed decision so she actually knows the impact of her plea. Otherwise, she's going to go ahead. She's going to think that she's golden. She's going to plead, get her daughter back, and then they're going to go into business. It's a little more complicated when, say in this scenario, the stepfather is also a biological father. There's two children living in the home. One is a stepchild, one is actually a bio child. He doesn't have a right to contest the count regarding the stepchild, but he could still contest. He could do it through his bio child. So it's probably going to be a J count regarding the bio child. So then if I represented the father in that situation, I would urge him to have a full-blown contest on the 300 J count to try to get to the D allegation regarding the stepchild, which he wouldn't ordinarily be able to try to contest. Does that make sense? So at the end of the day, really the best thing that you could do is know what the impact of the CACI listing is and what the impact of either a trial or a waiver will be on your client's ability to contest their listing and try to get off of it. I also have notes about the grievance hearing itself, but at this point, I think I'm going to take some questions since I've been talking for a long time.
So what if you get the A count dismissed or struck by agreement on a domestic violence count, and then there's the B count, and you can get the language changed to mother was unable to protect from the domestic violence?
Well, I think the question was if there's an A count and a B count regarding DV, and the A count was dismissed, and she pled to the B count for failure to protect, would that get her off the index? I mean, it's really going to be open to interpretation. I think there's a good argument that the elements of the penal code were not met because of that. But there's another step I do. So you're not going to know. So you're going to enter a plea, and then they're going to get the notice, the letter, and, saying we've received the sustained language. Based on the sustained language, your grievance hearing is now permanently denied. But what I do is I try to work out language prior to the court date. I send it to the grievance hearing review officer. I ask them if they'll share it with the county counsel who will be handling the grievance review case. It's all confidential. You're not violating anything. And sometimes I'll get.
That's not why I was making that face.
Why were you making that face?
It's just a lot to do
Yeah.
for Board of Community Council.
Very much so.
And how do you know what grievance officer to contact?
Well, you call the Office of Appeals Management. You have a reference number. The reference number will you tell them, this is my reference number. They'll tell you the county counsel and the grievance hearing officer who's handling the case. It is a lot of work, but at the same time, the reason I talked about the potential impact of the index at the beginning of the hearing is because this affects your client's livelihood in all likelihood.
There was a question from Lancaster that asked, did we have to take these steps in every case? And I think that part of this training is informative because sometimes our clients get the khaki notice and they ask us, like, what do they need to do? What do they need to do? So I don't know, maybe you could touch on it, but I just wanted to, the question from Lancaster to me was whether or not this was like a new LADL policy, and I think this training is to be informative.
Well, part of the reason for this training is to avoid malpractice. Part of it is to help your clients, and part of it is to avoid malpractice. That's a question. I think that if your client tells you they're on the index, and you don't give them, a knowing, if you don't tell them all the potential impact of their plea, I don't know if that's malpractice, but I think it could. There's an argument it could be below the standard of care. So you don't have to do all these things. I'm suggesting that, or telling you that I do, or suggesting that you do. But I think what you do have to do is during the intake, you have to ask them if they're on the index. At a minimum, this is what I would do. I would ask them if they're on the index, try to help them determine if they are on the index, and then I would tell them that you're not a khaki attorney. You need to hire a separate attorney to handle this. But these are all the potential repercussions of a plea in children's court. That's how I would handle it. So that would cover your butt, and that would also give them, enough information so that if they wanted to take it further, they could. Amy, do you have your hand up?
So from getting this right, even when it appears that the language or the facts of the case shouldn't necessarily bump the client up. So let's say you've done in the hypothetical that Emily gave. You've worked out your language. The language seems benign enough that it's not similar to the penal code section, and they get that letter of denial anyway. There's no further action that they can take.
So the question was, is there a remedy to denial of a grievance hearing if you think you have good cause to actually have a grievance hearing? There's one legal remedy, which I didn't cover, which I'll tell you now briefly. It's a writ of mandate. So you file the writ of mandate with the Superior Court, and you basically say that the policies were not followed appropriately, and then you state the facts why, and you attach the amended language. And then if the Superior Court agrees that what you said is accurate, that the language was sufficiently dissimilar, then they'll order that the grievance hearing proceed. I found there's a head grievance hearing review officer. His name is Michael Wachowski. I've actually found, yeah.
I was in court office for 3 years.
Yeah, I have some funny stories I could tell you in private. But I found he's a pretty reasonable person. And if you explain to him, your logic, why you think that the grievance hearing shouldn't have been denied, then he'll oftentimes reconsider it. I found them to be pretty fair. You just don't know who's making the decision. So there's a lot of turnover with the grievance review hearing officers. So the ones that aren't good don't last for long. So the ones they have now, I think, are all pretty.
In that hypothetical that was given, would the mother even appear on the index with a failure to protect, like a DV incident? Because it doesn't.
No, I don't think a simple failure to protect J accounts aren't going to put you on there. Certain B accounts are not going to put you on there. But it's more complicated because if their spouse is on the index, you know, I still think you have an obligation to tell them the potential impact on their family, so they can make an informed decision.
And then,
I mean, that's my goal. My goal is just to tell you the potential pitfalls, you know, and just tell them, and then they make a knowing, you know, decision how to proceed.
And about that potential impact, I wouldn't have guessed that doing IT would be something that this would be a problem for. We've kind of been telling people that it's like, if you want to work with kids, this could be a problem. Is this something that all government agencies check and they'll not take you on if you have a CACI hit?
So the short answer, do all government agencies do CACI background checks? No. But if there's a government agency that deals with sensitive issues, she does IT for a variety of government agencies. But I think there's probably a subcontractors list for disqualified companies. So I think once you're on that list, if you get one hit somewhere, then I think you're excluded from all the future government contracts. That's my impression.
So I understand that if a court of competent jurisdiction makes the finding that it occurred, then the grievance hearing is not required. So say you took something to trial because you were trying to get it dismissed and you really felt it should have been, it was found to be true, but then an appeal, does a successful appeal reinvigorate the right to a grievance hearing?
Yeah, I mean, absolutely.
Okay, so and how does, like,
so I would
be something to advise them to a CACI attorney to?
I would just simply write a letter to the chief grievance review officer, attach the appellate decision, and then request a grievance review based on that. I've had some similar situations that came up, and I've had initial denials of grievance hearing reviews that were subsequently overturned. I do administrative hearings, so I've had people that have lost the administrative hearing, and then their grievance hearing was reviewed, and then they appealed the administrative hearing results, and then we were successful, and then their grievance hearing was reinstituted afterwards. So yes, and a court of competent jurisdiction includes a criminal court. So if someone has an ongoing criminal case and they're found guilty of whatever the specific penal code section, they're also going to lose the right to grievance hearing. If someone is involved in a civil lawsuit and it's subsequently settled and then approved by the judge, that they're also going to make a factual finding. If there's a basis for the settlement, they're also going to lose a grievance hearing. So, I mean, they're looking for every opportunity to not give you a grievance hearing. My second hypothetical, for example, maybe wasn't great, but the problem in that case, in that situation, is, you know, step parents don't really have a lot of rights. So, and this is the same it's not just step parents. Say there's a foster parent who had the children removed from their care. They don't qualify for de facto status. The court, I mean, if there's a petition filed, if there's any language that involves the allegations, you know, they don't have any remedy whatsoever. If it's a de facto parent, then I would encourage them to file de facto parent status. But this comes up in adoption home studies. You could have a grievance hearing if your adoption home study was denied, and it's the same sort of thing. So if you have an adoption home study grievance hearing and you lose that and you're on CACI, you stay on CACI.
like a general drug count doesn't seem like it would fall under this either, correct?
No, I haven't seen listings for drug counts. They tend to go after the perpetrators. It's really sex abuse and serious physical abuse driven.
Okay.
But you know, anything that even smells of sex abuse, they're going to slap someone on the index.
Is it entirely discretionary on the DI or the social worker what they're going to request CACI for and what they're not?
Well, I don't know the answer to that question. I mean, there might be different offices might have different policies, different counties might have different policies. I really didn't go into this in my presentation, but I represent a lot of people that don't have children's court cases because the DI and the supervising social worker determined after weighing all the evidence they didn't think the 300 petition would be sustained, so they went ahead and just placed him on the index. So I think probably 50% of the people on the index would have had weak 300 petitions filed against them, But my experience in LA County is it's just the DI and the DI's supervisor. And if once, they're not, first of all, they never file a 300 petition unless they substantiated the allegations. So I found it sometimes it's a personal thing. If your client gave them a hard time, they'll do the double whammy. They'll file the 300 petition and stick them on khaki. It depends on the individual office, I think.
What has been your experience with domestic violence for both perpetrator and victim?
I haven't seen anyone listed on the index for domestic violence, although I could see it as an emotional abuse.
Okay. And that's even if it's listed as an A?
I haven't seen it.
Okay, thank you.
I mean, I think they could do it. I think it qualifies, but I haven't seen it.
Even if you amend your language so that it complies with the penal code section, that it doesn't comply with the penal code section, but your court requires that when you do a waiver, you have to do no contest. Would that then not allow them to have the grievance hearing because it's a no contest plea?
So the short answer is it should not disqualify them for the grievance hearing, but it probably will. So they're going to see a waiver, and they're not going to even look at the language carefully, and they're just going to send that denial letter. That's when I suggest that you call the chief, we write a letter, or someone writes a letter to the chief grievance review hearing officer and explain why that's not disqualifying. It depends who's receiving the mail, basically. So I know that they're very overworked. By the settlement case, you're supposed to have a grievance hearing within 30 days. Within 10 days, a maximum of 60 days. And I think the typical grievance hearing that I've done has been 3 or 4 months after I made the request for a grievance hearing. So they're overworked. So sometimes it's going to be a staff member in the office that sees the sustained petition or the no contest plea and then sends out the letter. But it's supposed to be the actual grievance hearing review officer who's assigned that specific reference number.
And can our clients take these steps on their own, or do they need a lawyer to go through this process?
So that's a good question. I'm glad you asked that. It serves my personal interest.
Can we repeat the question for Lancaster they're asking?
Yeah, so can a client basically do this in per? They try to have a grievance hearing, request one, and participate in one? Or is it helpful to have a lawyer? So obviously I'm very biased regarding this, but I've actually found that a surprising large percentage of cases will get dismissed without a grievance hearing the second that I notify them that I'm representing a person. They'll do that's on the index. So they have a policy that it's an unwritten policy, but if there's an improper person listee requesting a grievance hearing, they don't do a review prior to the grievance hearing. If there's a represented listee who requests a grievance hearing, they'll do an independent review, like a pre-trial, pre-grievance hearing with the grievance hearing review officer, and they'll pick up the phone, they'll call the DI, do you have any additional evidence? And if they don't, and they think the hearing is likely they'll be dismissed at the grievance review hearing officer, your client will get this great letter saying that, it's been determined we're going to be removing you off of the index without a grievance hearing, and then you look like a hero. So I think it's always in their interest to try to hire a lawyer because they're treated differently. And the actual grievance hearing itself, I should tell you about that a little bit. So it's the county council representing the DI or the DI supervisor, which is often the case because the DI is in the field, makes an opening statement and then calls them as a witness, there's a discovery process, they submit basically the Title 20s and the internal investigative reports, and then the parent has a chance to do an opening statement or just go ahead and call their own witnesses. The problem with the grievance hearings is you don't have subpoena power. So if they're relying on police reports, say it's a sex abuse case, there's no way to get the police officer there. If there's medical reports for serious physical abuse, there's no way to get the doctors who wrote the reports or did the forensic interviews at the hearing. So it's basically any witnesses that you could just voluntarily bring in. If the victim, your client is the parent, not the step parent, and they bring in their child to testify, to clarify, some issues, they'll take the child outside before the hearing starts. They'll take the minor outside of the conference room, and they'll literally ask him or her, do you want to be here? If they say, like, they had a field trip to school, no, oftentimes they won't even let you call the minor, even though they asked the question in such a leading way. So I've had situations where the minor 100% recanted the information in the report, and there wasn't even a 300 petition file. And I brought them to say that on the record, and then the grievance review hearing officer said, so what were you doing before you came here today? Playing, And do you want to be here? No. And then they wouldn't let me call. So that doesn't happen regularly, but it has happened. It's supposed to be a civil, you're not supposed to cross people like you will in court, so it's supposed to be very civil in the grievance hearing, very polite. I try to be the opposite because it's more effective. Social workers are not expecting me to be aggressive, but it's great. I mean, I've been able to ask social workers questions for 3 or 4 hours straight. But in important cases that are complicated, that's for that.
I can't remember if you said this already, but so for our purposes, if we're advising the client of the ramifications and they're unsure if they're on the index because they didn't receive the letter, and we advise them of the self-inquiry request, we give them this form. Do you know, is there a timeline for how quickly they usually find out from the self-inquiry if they're actually on the index or not?
Yeah, they're split. I might have not stated it, but if they do a self-inquiry, the Department of Justice is obligated to inform the requestee if they're on the index within 120 days. I've actually found that usually takes a little less than that, usually 30 days or so, and they'll find out if they're on the index. If you don't have the form with you and your client says they don't know they're on the index, you could just refer them to the Attorney General's website. And then on the Attorney General's website, there's a search bar. You can just put in CACI, C-A-C-I, and it'll have the form for either the self-inquiry or give them instructions on how to write just a handwritten letter making that request. But they do have to have that request, either requesting otherwise.
What is the range, the price range for representation for tech?
I think there's like 6 or 7 lawyers that do it. I used to take a retainer fee of between $4,000 and $5,000. I found that a lot of people couldn't afford it, and then even those that could, it just depends. I charge a flat fee now that's slightly higher than that. I just know it takes a long time to really go from the time you're requesting a grievance hearing to the actual grievance hearing. It depends on the case. So if it's a foster parent who's on the index, or a step parent who's on the index, you're going to have to file an 827 to get any discovery. So that's good. Sometimes it takes 6 or 7 months, and the client's constantly calling you. So I think the average attorney that does CACI hearings is probably going to charge $5,000 or $6,000.
And when settling a physical abuse count by reducing it to a B and having the language be inappropriate physical discipline, would that help a grievance hearing or hurt a grievance hearing?
I think it's probably close enough to the penal code language where it probably would keep them on the index.
That's close enough to the penal code language?
Yeah, I mean you have to.
And how about with sexual abuse, changing it to inappropriate sexual boundaries?
It depends if the purpose was done for sexual gratification. I actually made that exact argument, and it was unsuccessful in the grievance hearing. So it just depends. It depends on the grievance hearing officer. If you want to take it up on a writ, there's not going to be a magic answer. It's possible that the language is different enough from the penal code where you can make an argument. I had a case recently where it was 2 minors. I think the boy was 12, the girl was like 6. And they were basically playing doctor, and he did some touching, no kissing, no touching, and there was not an open children's court case, but they put him on the index for sex abuse, and one of the requirements for that particular statute was you have to do it for sexual gratification. So the boy testified, and he was saying he was curious, what her vagina felt like over her clothing. It was as innocent as that sort of touching could be.
It was research. It was academic.
You put the
Well,
12-year-old on the calculus?
Yeah, and he's not until he's 22.
Wow.
I had a case.
How did they even find out about it?
It was his cousin, and so his aunt reported it.
To
She
who?
actually called the police. They did an investigation. And they didn't file any criminal charges against him. They didn't file a 300 petition against his mother. Yeah. So I mean, yeah, just ruined his reputation. But there was no sexual gratification. I mean, there was other kids running around the room, and they still found that it was substantially similar to that penal code section, and they kept him off.
Wow.
If you get a dismissal in our court, is that automatic that you can get your name on package?
It's supposed to. They're supposed to get notice from the DI and immediately remove you. Obviously, you want to follow up to make sure they did it. But I found that I've never had a case where the petition was dismissed where the person wasn't removed from the CAC automatically without having to do anything further.
You always have to do something first.
No, I've never had to do anything further. I've checked. They've always done the right thing.
But that's, further after you had already requested a grievance hearing or not?
Yeah, I had requested a grievance hearing, reserved the right to a grievance hearing, did the 300, it was just the 300 hearing, the petition was dismissed against my client, and I followed up just to inform them of the results. They said they already knew, and they sent me a copy of the BCI form that they submitted requesting removal. The removal form is the same form that they use to place the person on the index. It's the 8583 form. They check out the box saying it's amended, and they just ask for removal. And I've never had a situation where the Department of Justice didn't remove the person from the index after that form was sent.
So is it true that grievance hearings do not consider nexus as a defense?
Yeah, that's true.
Okay, so if we've won the case on a nexus argument, that's not going to cause, that's not going to entitle someone to get off the.
They're just going to look at the same language. They're going to see how similar it is to the penal code. I mean, it's as simple as that. So.
But if an action occurred that would be similar to penal code described action, and the court dismissed it because there was no nexus to actual
risk
harm or risk of harm to the kid, what's the effect on the cat?
Well, just like a criminal court doesn't care about it only cares about the intent and the actions. It doesn't care about whether the victim was actually harmed. So let me give you a simple example for battery. If you spit on someone, it's battery. You don't have to injure them. It's just the actual act of spitting on them is a battery. So if the court found that the actual underlying actions took place, but there wasn't a nexus, and somehow the department found out about that, they would not remove you off the index. So I'll give you another example that I wasn't going to bring up because I've never seen it, but maybe some of you have. The court has authority under it's either 360A or 360B to order a 301 contract. They made a finding that the person falls within the 300 subsection. So the court, and then doesn't take jurisdiction. So the court reviews the petition and the supporting documentation, makes a finding that the child is described by 300 whatever, and then orders a 301 contract. So that's a situation where there's a sustained petition, but there's no jurisdiction, and the DI is going to go ahead and notify the grievance review hearing officer that the court did find that the underlying abuse occurred, and they're going to keep you on the index and deny your grievance review request.
Real quick, you mean 360B, right? Not
Yeah.
301?
What did I say?
You said 301.
Yeah, 360B. So is that Lancaster, do you have any questions?
Hold on just a second. So, one of the attorneys here had been under the impression that A's and D's and I's and, the more serious counts are automatically referred to CACI, but that's not the case, correct?
No, it's completely within the discretion of the DI and the DI supervisor.
Okay, so it doesn't come from the hotline call, it comes from the DI?
Yeah, they sit together in their office and they decide if they want to do the index listing and or the 300 petition. Otherwise, every single person that had a D would have it be on the index. I think it depends how busy they are, to be honest with you. I haven't found,
It's really hard to hear.
I'm sorry, say that again?
Can you repeat your answer? It's hard to hear.
Yeah, there's no steadfast rule. It's random. So someone could have a D alleged against them and they're not reported to the index. Just depends on the particular office and how they want to proceed. Everyone knows that some social workers are very aggressive, some supervisors are very aggressive, and others aren't. It just depends on their personality. They don't have a mandate. Maybe they should, but they don't have a mandate that they have to list every single person on the index that they substantiated certain abuse accounts.
Have you seen
So
any?
I have been told by county council in the past that the hotline call is the initiating person for the CACI referral. Is that not accurate?
It's not been my experience, but don't forget any mandated reporter is going to contact either the hotline, the police department, sheriff's department. It's the underlying agency that conducts the investigation that makes the determination whether to place them on the index or not. It's not the hotline worker.
And they make that referral whether it's been substantiated by the agency or whether it's been substantiated by the court?
The agency does their investigation. If they substantiate the allegation, then they refer them to CACI.
Before the court substantiates?
Yes, it's the same rule that they use before they file a 300 petition. They've already substantiated the abuse, and that's why they filed the petition. So they conduct their internal investigation, and then they go ahead, and once they substantiate it, they place them. If it's unsubstantiated, if it's unfounded, they don't place them. If it's substantiated, they place them on the index if they so desire. But they make that finding 100% of the time before they place them on the index.
So we're sorry if you already answered this question, but it's been really hard to hear. If the department refers an A and B on domestic violence, and obviously the A gets dismissed more often than anything else, then does the department take any responsibility for notifying the CACI that the A was dismissed?
They're obligated, if there's a request made for a grievance hearing, they're gonna tell the grievance hearing review officer assigned to the case what the results of the waiver, whatever language was worked out or sustained by the court. So they're obligated to do so. And if they didn't for whatever reason, that's a pretty easy remedy. You just have to, get a certified copy of the minute order. And maybe the transcript, and then send it to the grievance hearing review officer, or show them the language that was actually sustained, or maybe a certified copy of the amended language in the court file.
Thank you.
You're welcome.
So if a client doesn't request a grievance hearing for whatever reason, they didn't get it, they didn't understand it, whatever, but then the petition gets dismissed, does that CACI hit still stay in place because they didn't request the grievance hearing?
It stays in place, but in that situation, I probably would claim they never received a notice at all, since they can't prove that they ever sent a notice. But I mean, if they're honest about it, which of course I guess, if they haven't requested a grievance hearing within 30 days, then it's waived.
So that's even knowing that the response is going to be that the trial's pending, that it's put on hold, you still need to request it within 30 days, knowing that it's absolutely not going to be resolved in that time.
Yeah.
Okay.
Yeah, I mean, the letter is a little deceiving, because it actually says a request for a grievance hearing is denied. They don't tell you that it's on hold. So some people, think that they've lost their right to a grievance hearing. They have a successful experience in children's court, and they never revisit the issue. So that's another reason I'm telling you. So they're going to get that letter 100% of the time, as long as there's an open case in children's court saying their grievance hearing request is denied. If you look at the form, I think it's the 832 or 834. The 834, at the very top of it, says no grievance hearing shall be required when a court of competent jurisdiction has determined that suspected abuse or severe neglect has occurred. Or when it's pending before the court. So, I mean, they still expect you to make a grievance hearing request. You still have to send that form in. I think they do it just because they're hoping, people will see that. They don't have the right.
No point.
Yeah.
That's it. Any more questions?
Thank you, Paul. We appreciate your coming.
Thank you.
A lot of work. I guess that.